Hello, everyone, and welcome to Uncivil Law. I hope you are having a wonderful day. And we are here with a decision that just came out, I think, 2 hours ago from the Court of Appeals for the D.C. Circuit. This is the case of Richard Blumenthal and others versus Donald J. Trump in his official capacity as President of the United States of America. So this is a lawsuit filed by 215 members of Congress against Donald Trump for purported violations of the emoluments clause. As far as I'm aware, this is the first decision. No, I don't think it is actually the first decision from a court of appeals. I think we have seen other decisions on this issue before, but it's another in the list, and it's another one saying that there's no jurisdiction for the court to hear this because of standing. But we're going to read the whole decision, and we're going to analyze it, and I will explain anything that needs to be explained. So let's get started with this. Very exciting. So this came out today. All right, this is filed per curam, which just means on behalf of the entire court. So there's no signed author on this decision, and I don't really know how the courts decide whether it should be per curam or not. Per curam doesn't necessarily mean unanimous. For example, Bush v. Gore was per curam, and it was decidedly not unanimous. So I'm not really sure on what basis they say it's per curam or not, but it just means it's issued in the name of the court as opposed to any particular author. But there's no dissent, so it's 3-0. Anyways, per curam. In this case, 215 members of Congress sued President Donald John Trump based on allegations that he has repeatedly violated the United States Constitution's Foreign Emoluments Clause. The district court's denial of the president's motion to dismiss begins with a legal truism. When members of Congress sue the president in federal courts over official action, a court must first determine whether the dispute is a case or controversy under Article 3 of the United States Constitution rather than a political dispute between the elected branches of government. Fair enough. I mean, the case or controversy language is in Article 3 itself. That's all courts can do is hear cases or controversies. So yes, it's a very truism. Although undoubtedly accurate, the district court's observation fails to tell the rest of the story, which story we set forth infra, which means below, as opposed to supra, which means above. Because we conclude that members lack standing, we reversed the district court and remanded with instruction to dismiss. So the district court said there was standing. The Court of Appeals says unanimously there is not standing, and that is not a major surprise because I think it is a fairly generally accepted opinion among lawyers that the Court of Appeals for the D.C. Circuit is the most restrained when it comes to issues of standing. They're the least likely to find standing. So standing in broad, just to explain what that means, and I'm sure the court may get into this a little bit, but standing just means that you have a personal injury that you can sue for. So the clearest example I can give of this is, if there's a car accident, if you're in the car, you have standing. If you're just watching on the side of the road, not so much, because you're not injured by the car accident. Unless, of course, a wheel comes off and hits you, but that wasn't the point of my example. So, the idea is that you have to have some personal injury. That's the easiest way to put it. So, I break a contract with you, I harm you in some way, breach of contract, tort, you have standing, you have a legal right that you've been hurt. Either I've taken something from you or I've done something to you. It's to you, and so you have standing. That's what standing is in broad aggregate. And so they're saying there's no standing here, and the D.C. Court of Appeals is probably the most restrained on finding standing. So it's not surprising they didn't find standing. Trouble that in one of the weak sides of the Republic was their being liable to foreign influence and corruption. The framers prohibited persons holding any office or profit of trust under the United States from accepting from a foreign sovereign any present, emolument, office, or title of any kind whatsoever without the consent of Congress. Trent Dow gives me $5 in super chat. Thank you, Trent Dow, for the beer fund. Happy Friday, and thanks for the coverage. You are welcome, Trent. You are a scholar among participants for your super chat. Thank you. It is always appreciated, and I will enjoy that beer. Yes. Justice Joseph Story described the clause as founded in just jealousy of foreign influence of every sort. I like this use of the word jealousy, because it's using the word jealousy very precisely. You know, um, jealousy is fear of something being taken away from you, as opposed to envy, which is when you want something. So if I'm worried about something being taken from me, it's jealousy. If I'm envious of what someone else has, that's envy. So it's a technical difference between jealous and envy. So it's founded in the just jealousy of foreign influence. So fear of losing what you have to the foreign power. So I like that because it's a very technical use of the word jealousy, and so I like that from a linguistic standpoint. So I will take note of it and smile. Although he found it in Although he founded it doubtful that, in a practical sense, it can produce much effect, because a patriot will likely not be seduced from his duties to his country by the acceptance of any title or present from a foreign power. An intriguing or corrupt agent will not be restrained from guilty machinations in the service of a foreign state by such constitutional restraints. Okay, fair enough. Yeah, it may not do any good because people who would be corrupt won't care, and people who would be righteous wouldn't be influenced by it anyway. So that kind of makes sense to me. Members of Congress, again, members allege that President Trump has a financial interest in vast business holdings around the world that engage in dealings with foreign governments and receive benefits from those governments, and that by virtue of financial interest, he, the president, has accepted or necessarily will accept emoluments from foreign states while holding the office of president. They allege the president's failure to seek and obtain congressional consent has completely nullified the votes that are authorized to cast or approve or disapprove his acceptance of foreign emoluments. I'm sure Congress would approve, no problem, right? They further allege the clause is unique. Without more, that always troubles me. I mean, every clause of the Constitution is unique in its own way, right? They're all special and they're all unique. They all are deriving at something in particular. So it's like saying a snowflake is unique. Yeah, but in the same sense, like it's like other snowflakes. How is it unique? First, the clause imposes a procedural requirement obtaining the consent of Congress that federal officials must satisfy before they take a specific action, accept any emolument from any foreign state. This requirement of a successful prior vote, combined with the right of each senator and representative to participate in that vote, means every time the plaintiff accepts an emolument without first obtaining congressional consent, plaintiffs are deprived of the right to vote on whether the consent to its acceptance. I'm not sure it necessarily has to be in advance, given the language, but okay. I'm not sure it necessarily has to be in advance, but okay. Second, the Foreign Emoluments Clause regulates the private conduct of federal officials. Because President Trump is violating the clause through his private businesses without the need for government funds or personnel, Congress cannot use its power of the purse, normally the ultimate weapon of enforcement available to Congress, to stop him. Without that tool or any other effective means of forcing President Trump to conform his personal conduct to the clause's requirement, the members have no adequate legislative remedy for the president's denial of their voting rights. Well, not to put too fine a point on it, but you do have a legislative remedy, namely impeachment. You can impeach the president. You could have impeached the president for violation of the Emoluments Clause. You could have put it in your charge. That would have been a legislative remedy because, as I said many, many times on this channel, to the point I think people are tired of hearing of it, impeachment is political, not legal. So could you have impeached the president for violating the Emoluments Clause? Sure, you absolutely could have. So you have a legislative remedy. So, there's always that. You didn't take advantage of it. You went to court. So, just saying, you do have legislative remedies. Whether or not those will be successful remedies, of course, is a whole nother set of problems, but that's like going to court and asking whether or not you'll have successful remedies. If you have a good cause of action, yes. If you don't, no. So, okay, you could have appealed to yourself, but no, you didn't do that for some reason. Yeah. Okay, hold on. Let me fix the audio issue. Hold on. All right, that should be a lot better now. Sorry about that. I was trying with something and I obviously had problems with the sync. But yeah. Anyways. The members filed their complaint on June the 14th, 2017, seeking declaratory and injunctive relief against the president in his official capacity. The president moved to dismiss, arguing that the members lacked standing. No cause of action authorized their lawsuit. They failed to state a claim upon which relief could be granted, and the requested relief, an injunction against the president in his official capacity, violates the Constitution. The district court bifurcated these issues, which means split them in half. So you can have bifurcated issues, bifurcated trials. Like, it's not unusual for trials to be bifurcated. Like, you normally have a guilt phase and a penalty phase at a trial. So that's what you mean by bifurcating, right? You're dealing with some issues at one point, some issues with another point. So you could even, like in a jury trial, like theoretically, like argue part of a case to a jury, have them go back and decide that, and then argue another part of a case and have them decide that separately. So that's basically meaning we're splitting the issues and having them analyzed separately. So that's bifurcation. Very, very normally done for penalty, rarely done for substantive issues, but I have heard of it happening. But yeah. The president then moved to certify the district court's standing order for interlocutory appeal. So he's asking for the right to appeal while the trial is ongoing, which makes sense, right? Because the district court is saying, hey, President, you have potential liability for this. So we're going to go forward into discovery and go forward into, some kind of trial practice. And he says, no, I don't want to do that. I want to skip ahead. Now, normally you can only appeal when a case is finished, but you can ask for permission to go and appeal in the middle of a case for various issues. And he's asking for the right to appeal because, well, it would expose him to discovery for starters. And that is this whole set of problems when you're talking about, one political branch investigating another political branch. So, there's obvious issues here that might need to be resolved first. So he's seeking permission to do interlocutory, which means while the underlying trial is still pending. And then they stated a claim under the clause. The president moved for interlocutory appeal, and the motion was denied. The president petitioned for our court for a writ of mandamus. So a writ of mandamus is just a order. It's an order from a court to some lower body to do something. So it can be to another court, to a lower court, or it could be to an executive branch official. So if you are having problems with the executive branch, giving you problems, you might not be able to appeal it, but you might be able to get a writ of mandamus. So they're not done with you, so you can't appeal, but you can go to the court and say, they're just like not treating me properly. Order them to actually do their job. And so you get a writ of mandamus. That's what it is. It's just an order from a lower court, an upper court to some lower body, judicial or executive, to do something. I never heard of writ of mandamus to the legislature ever, but maybe it's possible. I don't know. I've never heard of one, but maybe. Having this, okay, and this motion, so that motion was the writ of mandamus. We denied the petition without prejudice, which means, we're saying no, but we're not saying you can't ask again. But we remanded for the matter for immediate reconsideration of the motion to certify. So we're saying, okay, we're not. So the district court refused to certify the interlocutory appeal, right? So that's the district court's decision initially, whether or not to certify that interlocutory appeal. Some are as a matter of right and some are discretion. So you're asking the district court for the right to appeal immediately. The district court said no. Okay. So then you go to the Court of Appeals, and you can't go on the issue at hand because you don't have a right to appeal. But you can get the writ of mandamus, right? So it's a brand new action. It's a brand new action, and you're asking for a writ of mandamus. Hey, upper court, order the lower court to do something. And the upper court said, we're going to say no, but we're also going to remand to the lower court for you, lower court, to immediately reconsider your decision, whether or not you're sure. So we're not reversing you, but we are going to suggest that you should consider your position again. So, that's probably a hint. All right. On reconsideration, the district court certified both the dismissal and the state it's proceeding. The district court got the hint. Congratulations, district court. Yeah, we're not ordering you to do it, but we are telling you should probably think about it again. And the district court said, okay, I've thought about it. Now I'm going to grant the appeal. Yeah, because, it's a little face saving, right? So it's like, yeah, I'll do that. Okay, that's kind of funny. On appeal of the dismissal denial, we review the district court's legal determinations de novo and assume the truth of the plaintiff's material accusations, as always, right? So this is effectively the same posture as a motion for summary judgment. It's not a motion for summary judgment because there's not been a summary judgment. Or the effect there was, it was the other way, right? The summary judgment was the case can continue, which is not normally what we think of as a summary judgment. But for the purposes of this exercise, let's consider it a summary judgment. So it wasn't a summary judgment, your case is dead. It's a summary judgment that your case can continue. So you can treat it like that. So we're treating the legal issues de novo because they're new, but we assume everything in the light of the person who's making the argument below, the person who is the non-moving party. So we make everything in light of the plaintiff. So we're going to give every benefit of the doubt to the plaintiff because we're effectively trying to determine whether or not they have a case, because of standing issues. And again, the DC Court of Appeals is the most restrained on standing issues. I think that would be a fair characterization. Most lawyers would agree with. I've at times, although I've not had pleasure of working in the DC Court of Appeals because my issues are exclusively federal circuit, I've known of cases where they've dismissed standing. I thought, like, really? So they are really restrained on standing issues. Okay, so now that we're going to get into analysis. No principle is more fundamental to the judiciary's proper role in our system of government than the constitutional limitation of federal court jurisdiction to actual cases or controversies. Standing to sue is a doctrine rooted in traditional understanding of case or controversy. Sure. To establish Article 3 standing, a plaintiff must, as a irreducible constitutional minimum, nice language. I'm not sure it's necessary language because it's just a requirement. But if you want to say irreducible constitutional minimum, sure. Suffer an injury in fact. So that was kind of like my car example, right? If there's a car accident, if you're in the car, you have standing. If you're watching on the side of the road without more, you don't have standing, right? Injury in fact. You have in fact been injured. That would be number one. That is fairly traceable to the challenged conduct of the defendant. That's what we call proximate cause. So actual cause versus proximate cause. So like, what would be a good example? I guess the car accident would be like a reasonable example. So a car accident happens, a wheel flies off, the wheel hits a thing, which hits the thing, which hits the thing, and in Rube Goldberg fashion, that is what hurts you. And so the question is, can you blame the automotive person for this series of unfortunate events? So that's proximate cause, yes. The auto accident was the actual cause, ultimately, of what happened to you, but it might be too attenuated to count. That is proximate cause. We use it in tort law all the time. So yes, you have to have actual cause and you have to have proximate cause. It has to actually have happened to you and it has to be close enough to count. What is close enough to count? Well, that's what we get the courts for. Yeah, but it's nothing new. And that is likely to be redressed by a favorable judicial decision. In other words, there's something a court can do about it. It has to be judiciable. There has to be something a court can do it. And that you have to be like, that we can do it if we were to rule in your favor. So if you win, can we do something about it? That's always a good test for standing and judiciability in general. Can the court fix this problem? Courts cannot fix every problem. So that's a qualification. So pretty easy, right? You have to have been actually hurt. It has to be close enough to count, and we have to be able to do something about it. Seems pretty simple. Put differently, our standing inquiry precedes our merits analysis. Of course it does, because why do merits if you don't have standing? And focus on whether the plaintiff is the proper party to bring suit. Yep. Are you the right person? Have you been hurt? If you've been hurt in an accident, as you've heard of like every TV lawyer commercial ever, if you've been hurt in an accident, see that if predicate is actually kind of important because you have to have been hurt in an accident or hurt by the emoluments clause breach in this metaphor. All right. Reigns is our starting point when individual members of Congress seek judicial remedies. Excellent. In that case, 6 members of Congress challenged the constitutionality of the Line Item Veto Act, claiming it unconstitutionally expanded the president's power and violated requirements of bicameral passage and presentment by granting to the president, acting alone, the authority to cancel and thus repeal provisions of federal law. The Reigns plaintiffs alleged they were harmed because the statute diluted their Article 1 voting power. The district court found the Reigns plaintiff had standing, but on direct appeal, the Supreme Court reversed, holding they lacked standing. Yeah, fair enough. All right. The line item veto was ultimately ruled unconstitutional for other reasons, but members of Congress weren't the ones able to do anything about it. Sure. This case is really no different from Reigns. The members were not singled out. Their alleged injury is shared by 320 members of Congress who did not join the lawsuit. Right. So, like, to the extent you've been injured, everyone was injured. And, like, you know, so it's not targeted at you. It's targeted at the collective. And, you know, collective remedies, an individual's ability to get redress for a collective harm is an obvious standing issue. Because, like, it would be like a membership organization you belong to be hurt. The membership organization could bring suit, but not you personally, probably. So could Congress as a whole bring suit? Probably. But we're talking about individual members of Congress, not Congress as such. So there's a distinction there. It makes sense. And their claim is based on the loss of political power, which suggests it's a political question, right? If your claim is loss of political power, it suggests this is a political issue, which means it's not a legal issue. Political is not legal, is not political. Yeah. We can therefore resolve this case by simply applying Reigns. That is, we need not and do not consider whether or how Reigns applies elsewhere in order to determine that it plainly applies here. Sure, courts typically don't decide issues that are not before them. That is judicial small c conservative. You only deal with the issues in front of you and you don't speak to broader issues. That's judicial small c conservative, which courts in general all are. They're all generally very small c conservative. They generally stay within the box. Just how the legal system thinks. They links things very discreetly to the matter at hand. The Supreme Court recent summary reading of Reigns that individual members of Congress lack standing to assert an institutional interest of the legislature. See, so what they're saying there, right there, is, look, individual members of Congress, you can't assert issues that belong to Congress. You're looking to ways Congress has been hurt, not how you've been hurt. You're a member of Congress, not Congress. If Congress itself wants to bring suit, you know, we'll talk because it's issues to them. And then we're probably still going to rule it's a political question, incidentally. But, you know, at least they would have standing, but we're going to dismiss it for a political question, probably. But in either way, it's like you as individual members are not Congress. You don't have the redress here. Yeah. So the House summary of Congress lacks standing to assert individual interests. In the same way, a single House, a bicameral legislature, lacks capacity to assert interests belonging to the legislature as a whole. Yeah. So even if the entire House had voted, it still is not the same thing as Congress. The House is not Congress. You know, and that is like a very minor point of personal critique I have. Because a lot of people, when they say Congress, they mean the House. But technically speaking, not technically speaking, in reality, the Senate is part of Congress too. So you could refer to a senator as congressman, and it would be correct because they are a member of Congressman. They won't like it, but it is correct. If you want to refer to a member of the House, the proper title is representative, not congressman. So just in case you want to know the difference, congressman technically refers to members of either branch. Wouldn't recommend trying it with a senator, but it would be correct. Representative and senator are your words if you want to keep them separated. Here, the individual members of Congress conceitedly seek to do precisely what the prior case law forbids, which asserts members entitled to vote on whether to consent to officials' acceptance of foreign emolument before it is not a private right in a personal capacity, but rather prerogative of office. Makes sense. The district court erred in holding that members suffered an injury based on the president depriving them of an opportunity to give or withhold their consent, thereby injuring them as their roles in members of Congress. After the prior case, only an institution can assert an institutional injury, provided the injury is not wholly abstract and widely dispersed. Right. So if the institution has been hurt, the institution can bring suit. If you've been hurt, you can bring suit. There's a distinction. So, yeah. The district court misread Raines in declaring that Raines teaches that it's not necessary for an institutional claim to be brought by or on behalf of the institution. Its confusion may be partially due to timing. The district court ruled before this other Supreme Court case, which was decided the following year. So to the extent they misread Raines, they didn't have the benefit of this other case that came later. So we'll give them a bit of a mulligan. Fine. Our standing inquiry is especially rigorous, and even more so because it's the D.C. Court of Appeals, in a case like this, where reaching the merits of the dispute would force us to decide whether an action taken by one or the other of two branches of government was unconstitutional. For standing, the members' inability to act determinatively is important, and conversely, the size of their cohort is not, so long it is too small to act. Right. Unless it is like a majority of both houses, then the fact is 215, we don't really care. It's just the same as 5. 5 is the same as 215 if it's not a majority of both houses. And it's hard to argue with that. I mean, it is, right? For standing, the members' inability to act determinatively is important, and conversely, size of the cohort is not. That is, we assess in this complaint, filed by 215 members, no different from our assessment of a complaint filed by a single member. I would agree with that. Because Raines and Bethune-Hill control this case, we begin and end our analysis with them. Okay, very simple. The members can, and likely will, continue to use their weighty votes to make the case to the American people, their colleagues in the Congress, and the President himself, all of whom are free to engage in that argument as they see fit. But we will not, indeed cannot, participate in this debate. Yeah. The Constitution permits the judiciary to speak only in the context of an Article 3 case or controversy, and this lawsuit presents neither. This is not our ball. We don't want it in our court. Go away. Because the district court bifurcated the motion to dismiss proceeding, 2 of its judgments are before us on appeal. With regard to the first, in which the district court held the members had standing, we reverse them with remand, with instructions to dismiss. The second, in which the district court held that members have causes of action and stated a claim, is vacated and moot, so ordered by a unanimous decision of the Court of Appeals for the D.C. Circuit. So, this is an issue on standing, which is always an issue in every case. You know, you have to have standing. You have to have a cognizable injury that you can identify to you. And it's also, incidentally, for this reason that the courts do not recognize what's called taxpayer standing. So, like, for example, if, I don't know, the Congress had funding for research of some disease that you were being impacted by, and they cut funding for that disease in favor of something else. You could say, well, I've been hurt, but I'm hurt as a taxpayer. And the courts are like, no good. You know, it wasn't targeted at you specifically. Congress is simply trying to choose among a plurality of priorities, and they decide yours is less pressing. And even though it's very important to you, you know, that's just, there's a lot of things that are very important to a lot of people, and some of which are arguably as urgent or more urgent than your need. So Congress, in choosing priorities, has the right to, you know, choose priorities. And so there is not, as a general rule, in federal law, taxpayer standing, although some states do allow it. But that's a federal rule. And so it's kind of the same thing here. It's like you're one part of a collective. That's not the same thing as the collective as a whole. How have you, Richard Blumenthal, been hurt? Well, I haven't had the ability to cast a vote. Well, you know, you've only been hurt to the same degree any member of Congress has. Every member of Congress has the same right to vote. And since the majority of Congress isn't raising the issue, you know, you're just one among many. You know, that this is just not something that's particularized to you. And as I've said before, this is not to be unexpected because the D.C. Court of Appeals, I think, is the most restrained when it comes to standing issues. Not the least of which reason is because they deal with so much political issues, because they are usually the Court of Appeals that deals with any administrative agency. So if you're suing an administrative agency, being sued by an administrative agency, odds are pretty good you're winding up in the D.C. Court of Appeals. So as a result, they tend to be restrained on standing so that's what's going on. So yeah. So Lint asks, would standing exist if a majority of Congress were to bring suit? Sure. If a majority of each house voted to bring suit, then sure, they would have standing. As a group, they've been individually harmed. And as I was saying a little bit earlier in the stream, though, then we get into the slightly separate question of whether or not this is a political question. So standing is the first issue, right? Do you have standing? Yes, you have standing. Great. Now let's move on to the second issue. Is this a political question? If you have Congress as a whole suing the executive branch, or I suppose vice versa, is that a political question? I would assume the answer to that question is probably yes. So yes, you have standing, but it's a political question, so we're not going to hear it for that reason either. So, standing, you have one, but you don't have everything, so that would be my baseline assumption. If the whole of Congress got together and sued the president or sued the executive branch as such, sure, you have standing, but political question doctrine is probably going to keep you away, I would guess. So, yeah. You'd have to have a majority of each house of Congress, not a majority of Congress as a whole. Because, do you have a majority here? Because you have 215 out of, no, just short of a majority, because you have 535 members of Congress. So 215, yeah, it's short of a majority. So yeah, if you can get a majority of each house, then sure, you have standing, but you're probably still not going to win. But this isn't really that surprising to me. You haven't been harmed. I think private individuals may have a better claim, especially if they can merge it in with some sort of unfair competition lawsuit. So, private hotel chains might have a better claim of action. I don't know for emoluments, but maybe for unfair competition, because of the president's title, maybe they can throw an emoluments clause in there somewhere that he's being enriched, and that's unfair and unjust. It would be unjust enrichment would be the claim. So you'd have unfair competition, and then you could say it's unjust enrichment, and the basis for unjust enrichment would be the emoluments clause. That might work better, and then you have a private entity would have a better cause of action there. I don't know how that would go, how that would work. You'd still have to show some sort of but-for causation. You'd have to show that people aren't booking with you and booking with the president because of things. So if you could get testimony from these foreign heads of state to that effect, that would be super helpful. Otherwise, you're going to have a bit of problem showing causation. You'd have a bit of problem showing these people would have booked with my hotel, but for the fact that it's the president's hotel. Because that's basically what you have to prove. You'd have to prove that they would have booked with you, but for it being Trump's hotel. And, that's a bit of a problem because, surprisingly enough, there are not many very high quality hotels in Washington, D.C. There's just not that many. I mean, the Watergate is high quality. Trump's hotel, regardless of what you think of the man, Trump's hotel is very upscale hotel. And beyond that, there's not a lot of competition in downtown DC. And Trump Tower or Trump Hotel is smack dab in the middle of smack dab. It's even more smack dab than Watergate. Watergate's much more closer to Arlington. So there's just not, if you're looking for the best of the best hotels, there's just not a lot of other places to go. So you'd have a lot of trouble showing but for cause. They would have stayed with me but for. There's just not a lot of high class hotels inside Washington, D.C. You can always stay at the Gaylord Convention Center, which is a very high class hotel, but that's all the way at National Harbor. Now, it's not that huge a deal because you can get a taxi ride into D.C. just that easily, but still, it's especially during peak time of DC, that's still an hour's commute and peak traffic. So, there's just not a lot of great options if you want to stay in DC proper. So, But I think that's like a better cause of action. Anyways, so for the 39 of you who are currently watching this stream, if you'd be so kind as to give this stream a like. If you like this, I just lost a like. I literally just lost a like right now. Wow, I'm hurt. I had 9 likes and then I had 8. Wow, that's not good. Anyways, if you would like to give me a like, I'd appreciate it. And as always, I very much appreciate the super chats. Thanks again to Trent Dow for the beer fund money. Very much appreciated. We will be on later tonight at some point with another edition of Supreme Court React. I don't know what case we're going to be covering yet, but we will cover something, and yeah, we'll go from there. So I hope you found this stream educational and informative. So that's the end for now. Until later, my friends, peace and goodbye.